Every street, shop and office runs cameras, collecting your image every day. But under GDPR, that footage is your data. Today, we show you how simple a DSAR or a data subject access request turns CCTV from silent surveillance into legal evidence you can control. You ask for footage and they say, we can't show you that. Watch how the law says otherwise and how to make them prove it. Welcome back to Know Your Rights by Scorpion Audits. Every Saturday we decode the law and every Sunday we test it via a case study. Today we are looking at GDPR and CCTV and your rights under DSAR, which is a data subject access request. Now, how to demand your footage lawfully, what deadlines apply, and what to do when a company hides behind policy. A data subject access request gives you the right to obtain a copy of any personal data held about you, including CCTV, where you're identifiable. If the camera can see you, the law says you can see what it saw. Under Data Protection Act, CCTV use must be transparent. Clear signage is mandatory, telling you who operate the system and how to contact them. If a sign doesn't name the operator or contact, that's already a breach. You can still file your DSAR. The sign itself is proof that they are the controller. Personal data means anything identifying you directly or indirectly. Face, voice, number plate, even gait. If you can be singled out, the data belongs to you. If they say, but you're in a crowd, remind them one identifiable face is enough. Myth number one, CCTV is exempt. There's no blanket exception that exists. Only narrow limits protects others' privacy or criminal inquiries. Otherwise, footage must be supplied and redacted if necessary. Blurring faces is fine, but don't blur the law. The controller, the person or organisation deciding how data is processed, must respond within 1 month and without charge. The clock starts the day they get your email, not when the manager's back from holiday. They can verify who's asking, but verification must be proportionate. A passport, a driving licence copy is enough, never full financial data. If they ask for a bank statement, reply, that's excessive under Article 12.6. Data controllers have 1 month to respond. For complex cases, they may add 2 months, but must tell you the reason and the new deadline. 30 days of silence, that's a breach. Screenshot it and escalate. Myth number 2, only police can request footage. Now, police have separate investigative powers. Your DSAR is personal. It stands alone under GDPR. The police ask for evidence. You ask for transparency. Both legal, but yours can't be ignored. Every medium to large organisation processing CCTV must name a data protection officer or contact for rights requests. Refusing to provide those details breaches the transparency obligation under Articles 13 and 14. If they say, we don't give that information, ask who handles complaints. Record the answer. No DPO contact is itself evidence for the ICO. Redaction balances your rights with others. Modern software allows blur, mute or crop, not outright denial. Privacy for them, access for you. Both possible, both required. Durrant versus the FSA 2003 defined personal data as data significant to an individual's privacy. Itihadi versus Cheney Gardens 2017 confirmed CCTV images count. Lloyd versus Google 2021 held that misuse can mean damages even without financial loss. So, when a firm mishandles your footage, that's not admin, that's liability. If a controller refuses, they must cite the exemption and inform you of your right to complain to the ICO. Silence or vague excuses breach Article 12. No reason, no refusal, send it straight to the Commissioner. The Information Commissioner can warn, fine, or compel compliance. Their power begins with your evidence. A 2-minute form can turn their no into enforcement notice. Myth number 3. Once deleted, it's gone. Deletion before expiry of the retention period to avoid disclosure breaches the storage limitation principle. Ask for their retention policy and deletion log. If they can't show it, it probably didn't exist. Police and councils operate under Part 3 of the Data Protection Act 2018. They can withhold only if release would prejudice an investigation and must confirm that in writing. They can delay, not disappear. Demand the written reason. It matters later. Private security often misuse store policy to block DSARs. Policy never outranks statute. If they waive a binder marked policy, remind them the Data Protection Act trumps policy every single time. Article 82 of GDPR allows compensation for material or emotional harm from unlawful processing or refusal. Ignore a DSAR, face a damages claim. It's that simple. So if you need to get access and want a copy of your CCTV footage, number 1, find the controller, check signage or receipt. Number 2, send a DSAR by email with date, time, location. Number 3, provide minimal ID. Number 4, mark the 30-day deadline. Number 5, if ignored, escalate to the ICO. And number 6, log everything, emails, screenshots, signs. So some key takeaways are, number 1, your image equals your personal data. Number 2, CCTV must have clear signage. Number 3, DSAR rights apply to that footage. Number 4, controllers must respond within a month. Number 5, refusing DPO details breaches transparency. Number 6, redaction is lawful, refusal is not. And number 7, ICO and civil claims enforce your rights. Now, GDPR isn't corporate jargon, it's actually public power. Every camera that sees you owes you accountability. In the next episode, we'll show you DSAR in action. So, all we ask now is please subscribe, stay informed, and remember, knowledge equals protection.